Hello all, happy day, happy Wednesday, happy New Year. I want to thank you for joining us today for the first of HR Profiles 2016 webinar series. Now, with the laws and regulations constantly changing about what you can and cannot do, ask, say, and see regarding employment screening, these webinars act as a resource for you to help you work through those gray areas, all while earning continuing education credits to keep your HR certificates up to date and current. I am Jane McFadden, the client advocate here at HR Profile, and your host and moderator for today's webinar. On top of these informative webinars, it is my job to make sure that there is no question in your mind that HR Profile is the best background check company in the industry, doing everything we can to make you a raving fan. If you have any questions or would like to contact me regarding this program, I can be reached at 800-969-4300 or janem@hrprofile.com. Today, we've got the pleasure of hearing from a partner with Taft Law Firm, the most prestigious employment firm in the country, Mr. Michael Byers. Mr. Byers is a litigator with more than 30 years' experience, representing clients from across many industries, including defense, physician practices, technology, manufacturing, retail, and insurance. And as a member of Taft's Labor and Employment Practice Group, he provides counsel to clients regarding employer rights, including wrongful discharge claims, claims under Title VII, the ADA, the FMLA, the FLSA, whistleblower and employer intentional torts, and any matters that are arising out of workers' comp claims. Today, we are excited to share Up in Smoke, What's an Employer to Do with the Changing Marijuana Landscape. This is where you'll learn what laws and acts to consider regarding drug testing, what your responsibilities are as an employer, and what you need to change or be aware of when marijuana legalizes, and what needs to be in your policy and handbook in order to remain compliant. If you have any questions during the webinar at all, please type them into the question box in the control panel on your screen. We will cover them as soon as we can. If there is a problem throughout the webinar, feel free to communicate with me either in that question box or in the chat box. I'll be checking that as well, and I'll work to address the issue right away. If your question doesn't get answered during the time allotted, Michael's contact information is here on the screen, so in the presentation, and then I'll also be sending it to you with your credit certificates and the slides from today's presentation. So, without further ado, here is Mr. Michael Byers. Take it away.
Thank you, Jane. Up in Smoke, what is an employer to do with the changing marijuana landscape? A marijuana presentation. Finally, a presentation that I can personally wrap my arms around. And I'm not going to tell you if I inhaled or if I partook along with my many other youthful indiscretions. As you may have gathered from the title of this presentation and my last couple of comments, we will try and have a little fun today with this presentation. And although I cannot see you or hear you, I'm quite sure you'll be laughing at my jokes. So, in Ohio, this past November, the voters have spoken with respect to the initiative to legalize marijuana, both for medical marijuana and, as they call it, recreational marijuana. And the voters threw out the marijuana initiative like a bunch of old bong water. It was soundly defeated. So you may wonder, well, why do we need the presentation today? Two reasons. One, this issue is not going away, particularly medical marijuana. 23 states have already legalized it, and others will be doing so in the future. And I suspect recreational marijuana and whether or not it should be legal will also return to Ohio and many other states. Right now there are, I believe, 4 states that have legalized recreational marijuana. And then secondly, this is just really incredibly interesting stuff. So without further ado, let's get going. Slide. Legalized and medicinal marijuana at the workplace. Well, as all of you know, employers continue to benefit from drug-free workplaces. I suspect that any of you that do drug-free workplace testing have positive tests come up now and then, and that allows you to eliminate job applicants and perhaps save major headaches down the road. Medical marijuana, medicinal marijuana, has created unknown territory and poses many challenges for a drug-free workplace. Slide. Now in Ohio, Issue 3 proposed the legalization of the use of medical marijuana by patients with debilitating medical conditions. Still required a doctor's note, but with that, it was legalized. It also proposed the legalization of recreational marijuana infused in products for personal use in certain amount for individuals 21 years of age or older. It did, thoughtfully, prohibit persons from operating or being in physical control of a vehicle, an aircraft, a train, or a motorboat while under the influence of medical marijuana, recreational marijuana, homegrown marijuana, marijuana-infused products. And it did require the General Assembly to think about this and come up with some laws down the road. We don't want your pilots under the influence of marijuana. Slide. Significantly, from an employer standpoint, Issue 3 did not in any way require an employer to permit or accommodate the possession or use or being under the influence of legal marijuana, recreational marijuana, homegrown marijuana, or marijuana-infused products. Slide. Statistically, as I mentioned, 23 states right now and the District of Columbia currently have medical marijuana laws where someone with a medical condition which is helped by medical marijuana, and we'll get into that in a moment, can use medical marijuana. The statutory language varies in each state, but it does allow individuals with certain medical conditions to legally use marijuana. Colorado, Washington, Alaska, Oregon, and the District of Columbia have legalized marijuana for recreational use, and they're having interesting issues with that. Clearly, marijuana continues to be the drug of choice. Positive drug tests have increased for the first time in more than 10 years at a 5.7% increase. You'll note there's some pictures on the slides. I'd like to thank our associates for posing. Very realistic. Slide. So what is medical marijuana? Medical marijuana, or medical cannabis, and that's just a fun word to say, cannabis. Come on, all of you say it, cannabis. It's a fun word to say. The use of cannabis and its constituent cannabinoids is medical therapy to treat certain diseases and to alleviate certain symptoms. And this just isn't a pothead's dream. The FDA has approved THC, which is the active ingredient in marijuana, to treat nausea and to improve appetite. People who do receive a prescription for medical marijuana are typically given a card from a doctor. Slide. So, medical marijuana, what are the reasons, what are the conditions that a person can use it if it's legal in their state? Pain is the main reason medical marijuana is prescribed. It can be muscle spasms that are caused by multiple sclerosis. Nausea from cancer therapy is very common. Poor appetite and weight loss caused by chronic illnesses such as HIV or nerve pain, seizure disorders, Crohn's disease, and glaucoma. Slide. So how is medical marijuana used? Probably most often it's smoked. It can be vaporized, heated until active ingredients are released but no smoke is formed. I'm not familiar with that. It can be eaten, usually in the form of cookies or candies, and I would add brownies come to mind as well, marijuana brownies. And I suppose it can be taken as a liquid extract. Side effects. Well, for those who are familiar with marijuana, it can cause dizziness, drowsiness, short-term memory loss, euphoria, and I would add the munchies. More serious side effects include severe anxiety and psychosis. So if you're using marijuana and you're having either severe anxiety or psychosis, you probably need to cut back. So what lawsuits have been filed involving medical marijuana? The most important point that you can get from this seminar or webinar as a practical implication is that state medical marijuana laws do not explicitly provide protective status to patients. The Supreme Courts in Ohio and, well, not Ohio, but other states that have allowed medical marijuana have upheld companies' decisions to fire employees for cannabis use on the job, showing up under the influence, using the cannabis marijuana outside the office. The judges have uniformly held that medical cannabis laws only protect the patients from criminal prosecution, from criminal penalties. It does not protect employees from termination by their employers for violating company policies with respect to drug use. Slide. The effects of marijuana use for employers typically decrease productivity. No surprise there. Poor performance, increased absenteeism, safety hazards, and as a consequence of all of the above, health insurance costs increases. So what if marijuana is legalized in your state, either medical marijuana or recreational marijuana? Employers will still be allowed to prohibit employees from working under the influence of marijuana, just the same as employers can stop employees from working under the influence with alcohol. An employer or employee cannot say, well, I had a couple Bloody Marys before I came into work today, but I did that on my time, at my home, not at the work site. If you're under the influence, the employer can enforce discipline against the employee. Same with marijuana. The real problem is going to be in testing. Unlike alcohol, excuse me, there's no test to determine marijuana intoxication. Although I will say that, most states have set levels of THC in your bloodstream where you are deemed impaired for driving purposes. And I suppose it'll be something along those lines. If you're in a state that legalizes medical marijuana or recreational marijuana, this will impact many different statutes. The Americans with Disabilities Act. Slide. Americans with Disabilities Act, the State Civil Rights Act, the Family Medical Leave Act, the Fourth Amendment, employment and union contracts, right to privacy, possible defamation, and workers' compensation. All of these will be impacted by the legalization of marijuana. So the responsibilities of an employer, slide, where a state legalizes either medical marijuana or recreational marijuana, must an employer accommodate? And the answer is no. All of you know, under the Americans with Disabilities Act, an employer generally is required to provide reasonable accommodation to a qualified disabled individual unless the accommodation would provide or would impose an undue hardship or cause risk of harm to the employee or coworkers. But marijuana use is still illegal under the Federal Controlled Substances Act, and therefore it does not need to be accommodated under the federal ADA. So the fact that an employee might say, I have a disability, no question about it. This disability will be helped by legal medical marijuana in my state. I'm asking to be able to use legal medical marijuana as a reasonable accommodation to help me with my known disability. The employer can still say no. As I mentioned before, 23 states have legalized medical marijuana use, which obviously creates a conflict between the state laws and federal law. Another point to remember is an employer may be put on notice of an employee's disability if the employee inquires about the company's policies regarding the use of medical marijuana. So, for example, an employee may say, I have a disability, I have glaucoma, I want to use marijuana. The employer may be able to say, no, not going to allow you to use marijuana, but the employer now is on notice of the employee's disability and may have to accommodate the employee's glaucoma through other means. Under the ADA, slide please, any test for illegal drugs that reveal the presence of legally prescribed medication must be treated as a confidential medical record, the same as other medical records. And of course, you all know that these medical records should be kept separately from the employee's personnel file. Under the ADA, again, a person illegally using drugs, which would be under the federal statutes, is excluded automatically from coverage under the ADA. And another tip is that the employer must treat those who do illegal drugs and alcohol users to the same performance and behavior standards applicable to all employees. You don't get a free pass and say I can't do the job because I'm an alcoholic or I am a drug addict. Slide. So what are the practical implications in Ohio? Well, medical marijuana has been and presently is illegal under Ohio law, and of course it's illegal under federal law. There are already initiatives being talked about in the State House to at least consider making legal medical marijuana, and I suspect that will be on the ballot before too long. But again, Ohio companies do not have an obligation to accommodate an employee's medical marijuana use and accept the employee from a zero-tolerance drug policy. So if you're an employer and if medical marijuana is legal in your state and an employee has a disability that is helped by the medical marijuana as an accommodation, the employer could say, you can't have any marijuana in your system. We have a zero-tolerance policy. Or the employer could say, if you use a little medical marijuana or recreational marijuana for that matter, on a Saturday night, but Monday morning at 8 o'clock when you punch the clock, you're not under the influence at all in the sense that you're not impaired. You have some in your system, you're not impaired. That's okay. The employer has to decide in those states that allow marijuana, what is its policy going to be? And it has to, of course, be spelled out to the employee clearly, and it has to be applied uniformly for all the employees. Obviously, the human resources personnel should know how to handle medical marijuana issues and questions as they arise. The next slide we can skip over because obviously, at least in Ohio, issue 3 did not pass. But generally, I would point out that employers, may not ask employees about prescription medication. Employers should not be able to ask employees about illegal drug use unless there's a suspicion. Obviously, you can ask if there's an issue with public safety. You can monitor employees that tell you they're taking medications. Next slide. Next slide, please. We'll talk about, let's go back one slide. Thank you. We'll talk a little bit about drug-free workplace policies because many of you have these policies. Drug-free workplace policies promote safety and accountability. The Act actually requires any entity that receives federal contracts with a value of more than $100,000 or that receives any federal grants to maintain a drug-free workplace. In addition, employees who work for federal contractors may be subject to discipline or termination if they use marijuana while on the job or show up under the influence, regardless of whether marijuana is allowed by state law. So keep that in mind if you work with federal contractors or receive federal grants or contracts. Slide. The Department of Transportation requires drug and alcohol testing of certain safety-sensitive transportation employees in aviation, trucking, railroads, mass transit, pipelines, and other transportation industries. It turns out no one wants a sky-high pilot in the sky. Marijuana's use under state law that allows it for either medical marijuana or recreational marijuana will not be excused from an employee's positive drug test result. Slide. And one of the reasons why is under drug-free workplace policies, under federal and state laws and regulations, employees generally have a duty to provide a safe place for all employees and vendors, frequenters to work. And the laws would support an employer's decision to terminate an employee who poses a threat to the health and safety of other workers due to impairment from use of medical marijuana or recreational marijuana. I'm talking about the forklift driver that just can't quite stay within the yellow lines. And when you're discussing this in the context of marijuana, it's just the same as alcohol or other drugs. An employee doesn't have the right to be a danger to himself or herself or others on the job. Ohio's drug-free workplace program, which is the section is cited there. Ohio has a drug-free workplace program that allows employers to drug test employees and applicants applying for a position. Employers who establish a program can and do qualify for a discount on their workers' compensation insurance premiums, and I believe it may vary from industry to industry, but it's a fairly substantial discount. It is worth looking into. In addition, there are further discounts if an employer engages in random testing and helps employees with rehabilitation. Slide. So drug testing is allowed, obviously, for applicants who are applying for work, so long as they are given prior notice given prior notice. You can't have them come in, fill out an application, and hand them a cup. Current employees, in the event of a workplace accident, always grounds for testing, or upon reasonable suspicion of impairment. And what if you have an employee who had a positive drug test, was off work for a while, says they're rehabilitated, says they're not using, wants to come back to work? Can you require that employee to take a positive drug test before coming back to work? The answer is absolutely. Slide. For employers to qualify for the workers' compensation premium discount, the employers must have a written policy in place. It can't be some loosey-goosey, well, this is generally our policy. It has to be a written policy in place. It has to provide for a company-sponsored employee assistance program. The employer has to pay for any testing. Slide. In addition, the policy must provide for education of employees regarding drug and alcohol abuse. It has to also provide training to supervisors regarding drug and alcohol abuse. And the testing must consist of a 5-panel drug screen plus alcohol testing that complies with federal drug testing standards. And the takeaway from this is you do need to work with your supervisors and managers. They're not going to necessarily know how to deal with marijuana questions. It's not something that may be intuitive, other than you can have a dangerously impaired employee on the job. Further, what should the drug policy contain? Well, the reason for the policy, and typically that's to discover and correct drug and alcohol use in the workplace and deter drug and alcohol use by others. The policy should state what it's designed to do, how it was developed, the employee behaviors that are expected, what legal drugs are allowed on the job. Again, legal drugs can be abused as well, as you all know. Substance abuse testing, what's the process for doing it, what's the procedure, precisely what will happen if an employee violates the policy, procedures for determining if an employee has violated the policy, slide, how appeals will be handled. You can be assured that if some employees have a positive drug test, they're going to appeal that. Efforts to help employees comply with the policy. How will requests for help be handled? How does the policy interact, or how is it affected by workers' compensation? Thought should be given as to how employee confidentiality will be protected, how fairness and consistency will be maintained, and there should be something that addresses the employer's employee assistance program if the employer have one, and we certainly recommend that employers do. Federal contractors require certain specific magic language as required by the Drug-Free Workplace Act. Slide. So drug-free safety program policies are administered by the Bureau of Workers' Compensation. As I mentioned, the premium discounts are offered for implementing loss prevention strategy. The program should have the following. Again, the written substance policy and operational procedures. What record-keeping practices will the employer have? Testing agreements, employees' assistance plan, how it will provide employee education and training. So at the end of the day, what are the best practices for you all as employers? One, and obviously, you should continue to comply with all federal regulations. They're not going away. Employers, however, are still in control and can decide what their policies will look like and how they will address claims related to medical marijuana use or even recreational marijuana use. But you shouldn't treat marijuana necessarily differently from other illegal drugs. It should be treated in the same manner. Most employers will want to ensure policies prohibit the use of marijuana in and outside the workplace, and of course provide for pre-employment and random testing. And a big question is the employers need to decide whether they're going to ban all employee drug use or merely impairment, and how will that impairment be defined and tested. Slide. Employers should communicate clearly to all employees and state what are the employer's expectations. As I mentioned, managers need to be trained about confidentiality relating to sensitive employee information, which would include drug tests and drug test results, and even requests for accommodations for medical conditions. A manager does not want to go around saying, Bob wanted an accommodation for this medical condition. You need to know the laws of the state where the employees work. So if you're an employer who are in different states, which is in different states, some states may allow for medical marijuana, some states may allow for recreational marijuana, some states may not allow for any marijuana. And then, as I mentioned earlier, the employer should be mindful that the information that the company receives regarding one's disability when an employee is asking for an accommodation may indicate a disability and the need for an accommodation other than getting medical marijuana. And that concludes the webinar. Thank you for your attention. I look much younger than that, by the way.
That was perfect, Mike. Thank you so much. And we have such a wealth of questions that have been coming through here. So I want to get started with those right away. One of the first ones is, what is the recommended level of nanograms for determining a drug test positive for marijuana?
And that's going to vary from state to state, and I don't know the precise number of nanograms, but if you look at your criminal statutes, for purposes of being deemed a driver who is impaired, your state will set forth a specific level, however it's tested. I don't know the number off the top of my head.
Okay. If we have facilities in multiple states, how do we follow all of the state-specific laws? Or will federal laws always trump the state laws? And should we follow the state laws where our headquarters is located?
Well, the federal laws will always trump the state laws, as we discussed, for purposes of whether or not an employer has to provide an accommodation of allowing medical marijuana for someone who has a disability. As to whether or not the employer wants to allow for the use of medicinal marijuana in a state where it has facilities in that state, but maybe not in another state. Well, besides perhaps union contracts, the employer faces a dilemma. Most employers, I would think, would want to have a uniform policy across the board. So if an employer is in a state that does not allow for medical marijuana and is also in a state that does allow for it, the employer may still want to say, we're just not going to allow any marijuana as an employer. Now, it's not illegal in the state that allows it, but we're just not going to allow it. I don't think it really makes a difference where the headquarters is, but generally, at least for ease of administration, and I think you want to have a uniform policy. I mean, I suppose if you don't have a uniform policy, you might even risk some type of discrimination claim saying, well, you allow for use of marijuana in this state, but not in another state, and who needs the lawsuit?
Right. You had mentioned at the beginning an increase in positive test results for the first time in years. What do you think has been the reason or the cause for that?
Well, I think in part, more and more states have allowed for the use of medical marijuana, and more states have allowed for the use of recreational marijuana. And I also think there seems to be, and this is good news, a lot of media coverage and coverage in the newspapers of the dangers of opiates and heroin. That use has spread to small towns, big towns, good school districts, bad school districts, and there are children, unfortunately, and adults that are dying of overdoses all of the time. I suppose a good part of the population feels that marijuana is much safer, and I suppose from a medical standpoint it probably is.
Okay. You had kind of mentioned, but this is a question, is there a way to prove that you're intoxicated on the job versus you just used over the weekend?
Well, it would have to come, unless you, a couple of points. I suppose if someone is so obviously impaired, they can't walk, they're very dizzy, they're slurring their words. If there's obvious impairment, you would view that as, hey, this person is obviously impaired, just like you would someone who's clearly under the influence of alcohol. But if it's not so obvious, I think the only thing you can do is to test. And obviously, if you test, I believe that marijuana stays in your system for at least 2 weeks, depending upon the quality of the test, and probably more like 30 days or longer, like, for example, with hair follicles. So you will know whether or not, they used marijuana, whether it was in the morning in the parking lot before coming into work, or whether it was 2 or 3 weeks ago. And if you have a zero tolerance policy, you'll know that that person is violating that policy.
Mm-hmm. Okay. All right. If it does, or when it does pass on the ballot for the different states, how long do companies have to change or amend or work with their policy? Are there time frames or limits?
That's a good question. At least in Ohio, they didn't address those types of questions. Once the law becomes the law, arguably employers should comply with the law. I think no state, no employer listening today is going to have this come up as a surprise. If your state is considering allowing for medical marijuana or recreational marijuana and putting something on the ballot or passing something through the legislature, it's going to be on the news. It's going to be well known to employers. And so I think that the best advice is to prepare, and you may not know, you're not going to know how the vote comes out, or if the legislature is going to pass certain legislation affecting marijuana, but it's not that terribly difficult to come up with what is our drug-free policy going to look like, and what is how are we going to implement it, and all of those things. And that's something obviously our firm has helped employers with.
Mm-hmm. Okay. Obviously, you practice in Ohio, up in Columbus, at our capital. But do you know any specific differences between, we're based here in Cincinnati, which is right on the edge of Kentucky and Indiana. Are there, or do you know of any specific differences between Ohio's laws versus Kentucky or versus Indiana?
I do know that Kentucky or Indiana or any of the other states that border Ohio have not legalized recreational marijuana. But to be honest with you, I don't know if Kentucky or Indiana are one of the 23 states that have allowed medical marijuana. That would be pretty easy to find out, I think.
Okay, yeah. Now, would your insurance rep be the person who would discuss the drug testing, workers' comp discounts, or who is it that provides those for companies?
Well, it's administered by the BWC, and I don't have the phone number. But if you call up the BWC and indicate you're interested in, getting a discount through a drug-free workplace policy, this is not an uncommon thing for the BWC. They can walk you through the process. And it may end up, you may end up being involved with your insurance broker as well, but it's really, the discounts are clearly administered by the BWC.
Okay. Mm-hmm. Now, if these, drugs, and you had mentioned heroin, and is there any duty for employers to report illegal drug use?
I'm going to answer that. Yeah, that's a good question. I've not, I've not, or if I did research it, I forgot it, which is possible these days. My gut reaction is probably not. Now, on the other hand, if someone is illegally using drugs and then they hop in a company vehicle and they take off down the highway, are you going to be found liable as an employer? Yes, you will be. Mm-hmm. But just to report, Mark, who toked up over the weekend, I don't believe there's a legal duty to report, but I would want to look into that.
Okay. All right. The DOT, they endorse a 5-panel. What advantages do you see to doing that, or a 9-panel or a 12-panel test? Is the 5-panel enough?
I think for most employers it will be. But again, it's clearly the choice of the particular uh, employer. The 5-panel is the minimum that's required.
And is marijuana on all of the panels that they offer? Is that kind of a standard?
I believe it is. I would have to look specifically, but I think the answer to that is yes.
Okay. Now, regarding a medical marijuana card, when someone has that and the MRO calls them, is there a way to prove or validate that that is a true illness or disability because they have that card?
I suspect that they have the card. I mean, boy, it sure seems like that would be, because they're not going to have that card unless they've had some doctor has signed off on it and, literally provided a prescription.
Mm-hmm.
Could the employer still say, well, I want further proof from your physician that you really truly have this disability? Probably, just like other disabilities, or whether or not a person has a serious health condition, employers typically have the right to follow up and make certain that they understand the disability, that that the employer knows or the doctor is aware of the person's job duties, and if they offer an opinion whether or not they can perform their duties with or without a reasonable accommodation, well, they have to know what the job duties are. So the law certainly allows for employers to follow up with physicians under limited circumstances. And I suppose if you had a good faith belief that the card is phony somehow, I don't know why you couldn't follow up with a physician.
Okay, yeah. So an employer does have a right to do that or look into it further.
I think so. I've not had that issue come up, but that's off the top of my head, that's my belief.
Okay, perfect. So our last question, and thank you so much, Mike. When is it acceptable to allow your applicant to retake a drug test?
Well, typically, if someone is, adamant about retaking a test because they just swear up and down there's been some error, I think most employers would allow for a retesting. I don't know that an employer has to allow for retesting, because there of course is some additional expense, but I think it's a good practice. I mean, if you had a valuable employee that was in an accident and tested positively for drugs, and that employee just swears up and down that there's no way they used illegal drugs, are most employers going to allow that employee to have a retesting? And the answer is probably yes. I don't know why it would be that different for an applicant, except obviously it's just a job applicant versus someone who's been on the job for a while. Okay,
yeah, right. There is one more final question that just popped up, and this is says it's to clarify, if it is legal and the employee is using it for medicinal purposes, can we still deny them a job?
Yes, if you're a company that has a zero tolerance policy, which is, and you're allowed to do that, then under the federal law, you don't have to accommodate the employee by allowing them to use medical marijuana even for a disability that the marijuana helps. You can simply say, our position is that there can't be, we're a zero tolerance company, and if you're using marijuana medicinally or as to help a disability, that's still our policy. That's perfectly legal.
Mm-hmm. And that would also allow for companies to say, we don't hire tobacco smokers.
Right. Well, I mean, the Scotts. Anybody who's seen lawn products is familiar with the Scotts company, which is headquartered in Marysville, a suburb. Well, not really a suburb, about 20 miles from Columbus, and they're a huge company, and they do not allow any employees to smoke on the job or off the job. That's just their policy.
Mm-hmm. Yeah, and so because it's written in policy, they're allowed to enforce it as their rules. And wonderful. Okay, wow. Well, that was such great information. Thank you so much, Mr. Byers. I'm sure that there are a lot of happy HR people who now feel like they can manage their drug testing better. So thank you so much. That is all we have for today. Thank you for spending an hour with us, or just under. Make sure you join us again in March when we're going to be discussing the Patriot Act and the terrorist watch list and exactly what you're searching when you search the OIG, the GSA, and those FBI watch lists. That webinar is coming up on March 16th at 2 p.m. The link will be sent to you and available in the email that you received from me, along with the slides from today's presentation and your education certificates. So we look forward to seeing you next time. Thank you guys so much.